Hello, welcome to You Can't Be Serious. This is my podcast. My name is Bradley Bailyn. I'm an attorney here in New York City, helping small businesses to grow and protecting the people who make the decisions for those progressive businesses. Today, I saw something that I felt just had to be discussed. I happened to stumble upon an article in the New York Times called My Shirt Avenged. It's by a gentleman named Rob Tannenbaum, and he went ahead and brought the dry cleaner to justice, who destroyed his shirt and told him he must have brought it in that way. Now, I think that has happened to all of us, where we check our car with the valet, or we park our car, or we bring something into the dry cleaner, and then the business tells you, oh, we didn't do that. You brought it in that way. And you say, well, why would I have done that? I would know. And they say, well, you did it. And I've always not had the time to pursue it, but I've always wondered if I have the legal right to do that, especially since they always have those signs up that say, disclaimer, it's your responsibility, blah, 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 or on the back of the ticket, it has the disclaimer. So, here's an introduction directly by Mr. Tannenbaum describing what happened and why. He says, when I decided to sue my dry cleaner in small claims court, snickering friends accused me of having crossed the line between principled determination and foolhardy obsession. Now that I've won the case, they've stopped snickering. And he says that his case began in the fall of 2000 when he gave 4 dress shirts to a cleaner on West 17th Street, and he paid $8, that's $2 each, and asked to have the shirts delivered. He says, I did not explicitly ask that the shirts not be ruined because I figured that was understood. When I opened the plastic days later, I found that my shirts had been washed and pressed except for one brightly striped Paul Smith shirt, which was wrinkled as when I dropped it off. But in addition, it now had a tear on the left shoulder. I surmised that some employee of New York Cleaners had accidentally ripped my shirt and then put it, along with its new 3-inch gash, on a hanger. At the Cleaners, I was referred to Raj Patel, who identified himself as the store manager. With great certainty, he denied that the store had torn my shirt. I pointed out the absurdity of paying to clean a ripped shirt, and I'm laughing because we've all been there. Then he pointed to small print on my claim ticket, which warned that the store's liability for a garment shall not exceed 10 times our charge for processing it. Grandly, he offered me a $20 settlement. The shirt had cost me $160, and I refused. At that price, I thought New York Cleaners could ruin 15 more shirts, kind of similar to the McDonald's hot coffee logic. And so Mr. Tannenbaum goes on to say that he needs to bring these kind of businesses to justice, which is why he brought this case. And what ends up happening is the judge sides with Mr. Tannenbaum. The judge says the issue is one of bailment for hire. When a bailee is unable to return the bailed item, or as here, returns it in damaged condition, a rebuttable presumption arises that the loss of or damage to the item is attributable to the bailee's negligence. And now, what is the public policy here in New York? I think this is what we're all wondering. The policy in our state is, New York law, however, has long disfavored exculpatory clauses that relieve a party to a contract from liability for the consequences of its own negligence. The law's disfavor has been expressed not in a prohibition of such clauses, but in strict requirements that the disclaimer of liability for negligence be made explicit and be communicated in such a way as to ensure that the party who is to be bound by the disclaimer has knowingly accepted such disclaimer as part of the contract between the parties. Okay. So, now, the court cites the leading case, which continues to be the leading case on this matter, which is Clark versus H&M Parcel Room. And at the end of the day, the court sets out a funny and interesting legal standard here. Basically, the court says as follows in the Clark case. Plaintiff's agent checked a package containing valuable furs in a railroad station parcel room, receiving from the attendant a cardboard claim ticket 3 inches long and 2.5 inches wide. On the face of the claim ticket was an identifying number printed in red type a 1/2 inch high. Also on the ticket's face, also printed in red, though in 1/4 inch type, was the word contract, below which, in smaller type, legible on close inspection, as the court describes it, was text stating certain purported terms of the contract between the parties, one of which read, "Loss or damage. No claim shall be made in excess of $25 for loss or damage to any piece." When plaintiff sought 2 days later to claim the package, it was gone, apparently having been given to another customer by mistake, which also happens at dry cleaners. And it's happened to me, and it's probably happened to you. Anyway, at trial, plaintiff's agent testified that he did not read the text on the face of the claim ticket, that he was not advised by the parcel room attendant to read it, and that he thought that it was merely a receipt for the package he had checked. Defendant offered no evidence of any other method by which plaintiffs might have been placed on notice of the liability limitation. The trial court awarded plaintiff a judgment of about $1,000, which was a lot of money when this case was decided in 1947. The appellate term modified the judgment, however, reducing it to $25, and then a higher court found that which that court found to have been communicated sufficiently. Then the appellate division, which is the higher court, reinstated the full $1,000 judgment of the trial court, reasoning that in the absence of a special contract, express or implied, and this is the relevant part here, in the absence of a special contract, express or implied, a bailee accepting baggage to be checked in its parcel room on payment of a nominal sum becomes a bailee for hire and is bound to exercise ordinary care in keeping and safeguarding the property. The measure of the bailee's liability for loss of the property through its negligence is the reasonable value of the property. The parties to a bailment, we're almost done here, the parties to a bailment may, however, contract to diminish the bailee's common law obligation with respect to the subject of the bailment, provided the contract is not in violation of law or public policy. The law in this state is well grounded that to bind the bailor to a contract limiting the bailee's liability, it must be established that there is a special contract to that effect, that the bailor has had reasonable notice of the terms and that he has assented to them. There is no proof here that that happened. What ended up happening in this case, in the case that we're currently talking about with the dry cleaner, is he said, "I just never read what was on the back of the slip." And the court found that not only does the disclaimer language need to be written somewhere, but the person needs to be affirmatively aware of it. To quote the court, in this case, it appears that defendants sought to enjoy the protections of a disclaimer without alarming its customers by causing them actually to contemplate the parade of horribles addressed in the limitation clause. And for that reason, the court awarded Mr. Tannenbaum the full $160 value of the shirt. So bottom line is, if you're a business, it's going to be very difficult in New York to exculpate yourself for your own negligence. However, it is possible to do it, but it's going to take a bit of thinking and legal analysis to arrange a set of circumstances which includes, but is not limited to, the language of the contract, which will in fact get you out of your own negligence. I've drafted contracts for people that do get them out of their own negligence, but again, as you can see, it's against New York public policy, so it's hard to do. If you have questions about this, feel free to email me at brad@bailynlaw.com, BRAD@BAILYN law.com, or call or text me at 646-326-9971. Please also feel free to subscribe to my podcast, where I cover a lot of funny and interesting things just like this. Thank you very much.